record it to the cloud.
There's plenty of storage on there. We're good.
Good. All right. Well, again, thanks everybody for coming. No magical tricks tonight. I'm going to share with you my experience with nearly now 12 years being involved with wind energy zoning issues. I hope that you guys are able to profit from what I have to say, but in the end, I don't live in your community. You all do. And what happens there doesn't really affect me from a perspective of land use policy. On the other hand, I've dealt with many developers in many states, and I'm aware of the various kinds of arguments and things that are made. And I hope that I can at least pull the curtain back a little bit and give you some confidence and some better understanding of the kinds of issues that you face. So without any more blabber, I'm going to go ahead and start my presentation. There we go. Is that up and going now? Nod a head up and down if it's working. Super. All right. Well, here I am. Here's a little bit about me. Lindsay already read a lot of that. I know that some of you have seen this map. I pulled it off the Facebook page, but you're wondering what's being proposed right now. We now have 137 participants, by the way. I didn't make this map, but in general, it shows the proposed project footprint of Apex's intentions here for your county. Apex is involved in other areas in Michigan and has been in the past. The red stars show places where they attempted to get some things going and they're abandoned. Shiawassee County nothing's happening there to the best of my knowledge. The townships they were approaching in Berrien County chose not to change their zoning. And of course, Isabella, they have an operating project. And then of course, they're busy now trying to get zoning approval in Montcalm and Midland and about 5 townships down in Ingham County. So that's what's going on there. So who is this guy? Well, as Lindsay already read, I have a number of credentials here. I worked for 2 years in my county drafting ag land preservation plans. I helped draft a wind energy ordinance that did become a state model. I'm certified through MSU Extension as an administrator and a citizen planner. And I have a degree from the University of Michigan. But then again, so does the Unabomber. So you can take that for what it's worth. Usually I like to be in person with you to see whether or not you actually laughed at that stupid joke. And just a quick note, I am the zoning administrator in Deerfield Township. Some of my colleagues are probably on the call tonight, but I'm not speaking tonight, obviously, as the zoning administrator, or nothing I say is meant to represent Deerfield Township government in any way. And here's the list where the RIGA ordinance was added to the list that the state used to maintain of various wind energy zoning ordinances. Now, I don't know what Gretchen Whitmer will do now, but Governor Snyder maintained a list. And for those of you who are working on your ordinances and some township or county officials we may have on the call, all my recommendations are based on my experience with the Riga Township ordinance. And if you want to see the Riga Township wind or solar ordinance, and that's where I live, it's right next to Deerfield Township, just go to rigatownship.com and you can find those there. And some more boilerplate. I'm not a lawyer, but I do watch Law and Order. I'm not offering legal advice tonight, and make sure you retain competent counsel for the work that you're doing with your ordinances. This is a very important point and one that I hope that folks keep in mind. The wind industry and their advocates, and I've seen this across the country, like to make these zoning deliberations a discussion about how noble, green, and beneficial wind energy development is. That's what they want to focus on. But from a zoning perspective, the only issue before us is how to safely place 50, 60, or 70-story tall noisy structures into a rural residential environment. Whether these structures produce green electricity, extract oil or coal, or turn sow's ears into silk purses is absolutely irrelevant. This is about separating conflicting uses of land and protecting health, safety, and welfare. Nothing more, nothing less. Secondly, to the officials that may be on this call, as a current zoning administrator and having been a planning commissioner in the past, I understand what it's like when a developer leases a lot of ground in your township and comes in and asks you to amend your zoning to make their project to go forward. And then you have a bunch of people who are really concerned about what's going on. It's nothing you probably ever anticipated when you became a township official. And it can be rather thankless. And I know that. I've been involved in that. I've been on both sides of those issues. And it's compounded by the fact that often the leases are signed up for wind or solar now in townships that presently don't have any zoning for wind and solar. So then they come with a political constituency of leaseholders, pushing for various changes. I appreciate what township officials do, and I think your service is noble, and I have been on your side of the table and still am. So I'm not here to beat anybody up. The good news is, so here you sit, half the people or a third of the people in your township want this, another half or a third want the other. Who knows where those numbers lie? Well, we'll talk about that in a little bit. But I think everybody wants to find a way to make everybody happy. And in my 11, 12 years of experience now, the only way to really split the baby in half is that if we adopt zoning regulations driven by two principles, consent and compensation. And if you put these principles into your zoning ordinance, you can take the pressure off of the board, off of the planning commission about whether a project goes forward, and you place it back into the hands of the private landowners and the wind company to negotiate easements. This is how it should be. I hope that becomes clear as we talk. Now I'm going to pop through this real quick. My group, the IICC, is a bipartisan group with supporters from left and right. I have no ties to any fossil fuel or industrial interest, period. I am not a paid lobbyist. I donate my time as a volunteer, receive no financial compensation for my time from any donations. And I know you've seen the online articles tying me to fossil fuel funding. They're false and without basis. The authors of most of those have received letters from my attorney to that end. I can't prove to you on this call that I don't have any fossil fuel funding any more than if I were to accuse somebody of beating their spouse, that they would be able to prove that in fact that's false. I can't prove a negative, but you hear my clear testimony on this right now. And at the end of this talk, I'll take questions for as long as anybody wants to ask. State and local officials first, and then the general public. So when it's time to raise your hand, and I'll show you how to do that, I just ask that you let the officials go first. There is only one line of questioning I will not address in this Q&A time. Again, the question of whether I have these dark financial ties to industrial or energy interests. I've already answered that. The answer is no. Secondly, if you really believe fossil fuel funding totally discredits a speaker, that is decidedly bad news for Apex or the folks at the Land and Liberty Coalition or Wind 101 and Peter Sinclair or the Sierra Club. They are all awash in fossil fuel and special interest money. Again, I am not and never have been. So I would love right now to start talking about zoning issues. But as you've already seen on social media and the various seminars and stuff in your community, the developers spend a lot of time talking about things other than zoning. They talk about money for schools, they talk about money for roads, they talk about economic development. Those aren't really zoning matters, and we shouldn't really be factoring them into our land use deliberations. But since so much time is spent on those, if I don't have some answer for those, I think I will not be doing you a service. So let me briefly analyze some of the economic claims and environmental claims that the wind industry promotes around the Midwest. First thing we need to know about Michigan's wind resource, and these are two maps from NREL, our wind resource is really poor. Our best wind in the thumb is Iowa's worst. As a result, our wind energy contracts in Michigan are substantially more expensive than wind energy contracts from Iowa or Oklahoma. Now, the Isabella County project came in at about $43 a megawatt hour, which makes it about the same price as an Indiana wind project that Michigan bought the energy from about 8 or 9 years ago. That was Wildcat Wind 1. In the meantime, all those intervening years, our wind contracts have run anywhere from $108 a megawatt hour down to the mid 60s. So we don't have a competitive wind resource. So while $43 in Isabella will be better than it has been in the state of Michigan, we see wind contracts out west now in the $15 range. So again, we're at a severe competitive disadvantage with our wind resource. And this is a chart showing PPA prices. The red line is Michigan, and you can see no matter the stage of development of wind turbine technology, Michigan stays more expensive. In fact, this date here is the Pine River project in Gratiot County. It was like $60 a megawatt hour at the time that project was approved by MPSC as one of the most expensive wind projects in the United States. So when you compare the tip of the thumb here with where we are here, you'll see your county really has a miserable wind resource. So why are we going to build here? That's the question. Simply building the turbines that they want to build in this county, if they build them out west, they would produce far more energy more cheaply and reduce far more CO2 compared to building them in here. I think that's a poor ratepayer and environmental value. And Consumers Energy concurs. They said in one of their reports to the state regulators, opposition to wind farm developments in Huron County and poor wind speeds in counties west of the thumb mean that wind build in Michigan may not be cost effective or a feasible option. We also know that renewable energy increases utility bills. This is recent. Consumers Energy wants to again raise rates. In this little quote there in the box, next year's $225 million increase would help pay for investments associated with solar generation, system reliability, environmental compliance, and enhanced technology. Your rates will continue to go up as long as we continue to build more wind and solar projects here. That's because we have regulated utilities who make their profit on building infrastructure. So what about the environment? That's the other big argument that we hear all the time. Well, we have to do this for the environment. Well, guess what? There's a growing number of environmentally conscious folks who are waking up to the fact that wind and solar are not nearly clean, green, or sustainable as its promoters or beneficiaries would have us believe. Warren Buffett, who's very concerned about the climate, he's a Democrat. He says on wind energy, we get a tax credit if we build a lot of wind farms. That's the only reason to build them. They don't make sense without the tax credit. James Hansen is one of the world's leading climate scientists, and I encourage you to watch this video. Renewables are not going to get us there. He says that renewables like wind and solar are never going to be built in quantities fast enough, large enough to ever make a meaningful impact on climate change and CO2 emissions. How about Michael Moore? He's released a documentary. I encourage you guys to check it out. It's called Planet of the Humans. Michael Moore, you don't get more left or environmentally concerned than him. And by the way, we have 151 folks on the call now. I'm one of those people who wanted to believe all these years that wind and solar was the right path. The director for that film is Jeff Gibbs. He's an associate of mine. He's asked me to review a book that's just come out in the last few weeks, so I'm waiting for a copy of that. His politics and mine could not be more different, but he says, it was kind of crushing to discover that the things I believed in weren't real, first of all, and then to discover not only are the solar panels and wind turbines not going to save us, but also that there is this whole dark side of the corporate money. It dawned on me that these technologies were just another profit center. So what about carbon dioxide? People who are worried about CO2 emissions talk about something called the social cost of carbon. In other words, let's put a dollar amount on how much harm every ton of CO2 emitted costs to our economy. The Obama administration calculated that at about $40 a ton. Well, some are arguing it might be 50, but it's in that range. When the Obama administration had their clean power plan, which Joe Biden may be bringing back, MISO, our grid operator, did a calculation on the price per ton of CO2 avoided by going through these various steps here in the clean power plan. Building block 3 says, let's add wind. And they said, yes, it reduces CO2, but at $237 a ton. That's 6 times nearly the social cost of carbon. So wind energy does reduce CO2 emissions, but not cheaply. Now let's take a look at local acceptance. So Montcalm County has, I think most people would agree, a fair amount of political turmoil. You're not alone. This is a map that I frankly haven't spent a lot of time keeping updated, but there has been a lot of turmoil about wind energy development all across the state ever since 2007. We've seen recalls, we've seen lawsuits, we've seen referendum, we've seen all manner of political ugliness. You are not alone in having concerns here at all. In fact, I'd like to point out for you a little bit on Huron County, a quick case study. As you know, up until recently, Huron County had nearly more turbines than the rest of the state combined. And it's been a free-for-all there since 2007. They built the thumb transmission loop up there, and the wind developers arrived. Every green star is where there's spinning wind turbines. The red stars are where there is not. But I want to focus on the 3 yellow ones briefly. In 2016, 3 townships faced even more wind development: Lincoln by DTE, and Sand Beach and Sherman by NextEra. Interesting about Lincoln, 4 out of the 5 Lincoln Township trustees had Detroit Edison wind leases. But even though they did, they took action to remove themselves from county zoning in order to enact protective zoning of their own. They told the Huron County Planning Commission, that's in the paper, we feel that Huron County has done our part as far as green energy. We feel that no additional turbines should be allowed in Huron County. This was wind leaseholders, 4 of them on the board in Lincoln Township. They were going to make money on this, and they could look out their window and see turbines and said, you know what, enough is enough. What happened in the opposition there is they ended up having 2 countywide zoning referenda and 2 township level referenda on the May 2nd ballot. DTE sent their CEO of their electricity division to Huron County to campaign for it. The messaging was kind of interesting. He basically came to Huron County and said if they would allow just one more project, they would never build another in Huron County. Well, that's interesting because their message prior to that is that wind brings nothing but blessings. Now they appear to be saying that, well, hey, we will never bless you again with wind energy if you just let us have one more. The folks over in the Next Era district got more aggressive. This was a flyer that went out to the people in their townships. Why is this lawyer smiling? Vote no on May 2nd. Vote no to protect Sand Beach Township from costly lawsuits. Can you imagine that? I think it's kind of funny. Somebody looked at this picture and said, oh boy, $43. Doesn't seem like much of a windfall for the attorney. And at the time, NextEra was suing townships in Tuscola County next door. So the threat of litigation was serious. And I will address that for your townships in a minute. The Huron County residents fought back. They picketed, they protested. They went door to door and circulated referendum petitions. The campaign disclosures after the fact revealed that DT and NextEra spent $875,000 on the campaign. The locals spent $3,700. And if I had fossil fuel money, by the way, I would have poured it into that campaign. I obviously don't have it. DT and NextEra have a lot of it. How did the results turn out? 64 to 36, both elections. Wind lost by a large factor up there. Wind losing at the ballot box despite these big campaign expenditures is not rare. Here's a list, I think now 24 townships that have had referenda on wind since 2009. Wind has never won a Michigan township referendum since 2009. One of the townships in Sanilac County, NextEra, spent 164 grand on PR in one township. They were handing out hats and shirts at the intersection on the day of the referendum election. The folks spent about $2,500 or $2,700 and they lost. The folks won, Invenergy lost. And frankly, dozens and dozens of townships and entire counties have rejected wind energy, including Mason, Emmett, Shiawassee, and Schoolcraft. And we see them continuing along that pattern. Branch County had several townships recently look at wind energy and decide it wasn't for them. And for the first time ever, I think last year in Gratiot County, a township rejected wind development there in Seville Township. They had a referendum and Invenergy was not successful moving forward there. So people say, and you heard Sarah Mills say it, and if somebody only talks about the negatives, then why would you listen to them? Well, there are benefits to wind energy. And let's be clear about that. The main benefit, though, is for the developers. Wind development is highly profitable for people like Warren Buffett and the other slide who owns Mid-American Energy, Detroit Edison, NextEra, Apex, Invenergy, etc. They are the leading beneficiaries of any wind development. And of course, the local lease payments and some increased tax revenue do accrue to the communities. But we have to look at these benefits inside a larger context. Wind developers talk about this money as an inducement for permissive wind energy zoning. They do this even though tax revenue isn't really a valid zoning criteria. And why would it be? Do we give more land use privileges to people who have more money than those who have less money? I don't think that's fair. That's not equal standing before the law. But not only are these revenue factors they want us to look at so closely irrelevant, the money that they use to pay those benefits to the in taxes and landholder lease payments are all recovered from Michigan ratepayers, employers, and from the U.S. Treasury in the form of tax credits. There is no free lunch. This cartoon illustrates it neatly. For those of you on the phone, it's a fellow walking down the street throwing money out of his wallet, and the husband and wife are watching on, and the husband says, look, he's giving us all money just like he promised. And the wife astutely observes, but he has your wallet. And that's where the money's coming from. That's why Consumers Energy just raised their rates. There is no free lunch here. We're paying for this. And another one we hear a lot is, what about saving the family farm? Well, my count shows there's 56,000 farms in Michigan. Maybe 500 farmers have a wind turbine and get the big turbine check. And that's because a lot of farmers have 5, 6, 7 turbines on their farms. One fellow in Ludington has 13, I think. By my count, less than 1% of Michigan farms receive substantial wind money. The other 99% of those farms pay for the 1%'s benefit through higher utility bills. This harms energy intensive dairy operations in particular. And as we all know, milk producers are struggling. And one final quick spot, and then I promise you we will jump into the zoning. The land use implications of low energy density resources like wind and solar are pretty interesting. Let's say you really hate nuclear power. Here's the Fermi plant over on Lake Erie. It's 1,100 megawatts of capacity, and it sits on roughly 1 square mile, one section. Let's say you wanted to replace that with wind. Well, back when I first made this map, the industry standard was 1.8 megawatts Vestas V100s. You'd have to put 2 of those in every square mile from Toledo, Detroit to Ann Arbor to replace the annual generation of that nuclear power plant. But even with that many turbines, in July and August, the wind often doesn't blow, which means you'd still need 1,100 megawatts of gas-fired generation. Drill down to the township level, one township full of turbines, something like this, 36 square miles, will typically produce the same amount of electricity over a year as you could produce from 1 or 2 of these gas-fired generators that sits on a semi-trailer and can be slid inside a dairy barn. So energy density matters. That's why we see so many turbines, but they don't really produce that much electricity for square mile of ground impacted. All right, now for those of you who are following along, we're going to get into the Zoning Enabling Act and wind energy zoning specifically. And there are a lot of things I could talk about. The list of things people want to regulate with wind is huge. We don't have time for that. I'm going to focus on height, setbacks, noise, and property values primarily. Now, here's another very important slide. So if you're a township official right now, this comes from a workbook I was given from MSU Extension in about 2007. And this chart has really stuck with me. And keep track of this, folks, and think of these things at your next township meeting. Beware of these zoning excuses, this says. Sad but true, far too many hearings on rezoning cases resemble a horse trading affair being carried out in a comic soap opera fashion. Some of the more ridiculous excuses offered for granting rezoning follow such lines as, here's one, you can't keep a man from using his land. Well, let me address that, by the way. If you're an official and you think you can't tell somebody what to do with their private property and you have a planning commission, then that's a serious problem, because the only thing a planning commission and zoning ordinance does is tell people what they can or cannot do with their private property. So if you really think you can't tell people what to do with their private property, the answer is to abolish your planning commission. Look at the next sorry zoning excuse. This will bring in more revenue. Now, mind you, MSU is telling us these are not valid zoning criteria. How about this one? They're too big of an outfit. We can't deny the rezoning. How about this one? He invested a lot of money in his land in these proposals, thinking the rezoning would be granted. How can we deny it? How about this one? His attorney said it's probably unconstitutional. Or this one, we don't want to have to go to court, and it doesn't look that bad. These are excuses, and they're not valid criteria. And so let's keep that in mind as we go through the rest of this. So you're a township zoning official or township board member. Our guidance, our regulatory guidance, our regulatory authority comes from the Michigan Zoning Enabling Act. And of course, the fundamental rule is that the ordinance shall be based upon a plan designed to promote the public health, safety, and welfare. In other words, if the proposed activity cannot be performed in keeping with health, safety, and welfare, it must not be permitted. Remember, a developer's primary commitment is to bottom line, and their recommendations are designed to maximize their return on investment. But a planning official's single commitment must be to health, safety, and welfare. How far can you go with zoning? How do you know if your zoning is legal, if it's supportable in court? The law says that zoning regulations must have a rational relationship to protecting health, safety, and welfare. They can't be arbitrary or capricious, like saying Protestants have to paint all their houses purple and Catholics have to paint them all orange. That would be arbitrary and capricious. If you don't trip over those things, in other words, if you have a valid governmental interest in applying the regulation that you have, it's almost unassailable in court. Reasonable zoning is very strong in court. Developers are crafty and present many superficially enticing arguments and promises, but protecting health, safety, and welfare is the sworn duty of township officials. And so our developers' profits, promised increase in tax revenue, claims of private property right, claims of green jobs or emissions more important than health, safety, and welfare? Absolutely not. And remember, it's health, safety, and welfare, not health, safety, or welfare that zoning commissioners are duty bound to protect. Too often I see people want to negotiate on the health and safety part in order to get more tax revenue welfare. Okay, now we're going to jump into some specific recommendations. Regulating height. So we got about 2,600 megawatts of wind turbines installed in Michigan, according to the figures I found. And when we started on this back in 2007, 8, 9, the state published some recommended guidelines of 1,000 feet from homes and 55 decibel noise limits. By the way, turbines were only 390 feet tall then. And as you can see in Montcalm County, those standards, which I feel are outdated because turbines are far higher, are still being promoted. And by the way, the latest generation of turbines now is 820 feet. So that's where we're headed next. So for a long time, the standard thing the developers would recommend was a 500-foot height limit. But now, because turbines are much bigger, I'm seeing a push for no height limit. And in the beginning, we saw 55 decibels, like in Huron County. Then they went to 50 because there was noise issues, and then to 45. I had 2 developers working in my township back in 2009, 10, 11. One wanted 55 and 1,000 feet. Exelon wanted 13, 20, and 45 decibels. In fact, I asked Exelon's noise expert if he thought that UV winds noise recommendations and setback distances were unsafe. He said, yes, they are. But yet he then went to Mason County and worked for Consumers Energy and approved of the short setback distances and high noise levels there, even though they were identical to the ones he criticized in my township. So then we saw Exelon and DTE pushing for 1,320 foot setbacks. Now we see it going back to 1,000. By the way, Huron County's at 1,640 now. 30 hours of shadow flicker, 1.1 setback of property lines and roads. So that's what we're seeing is what the industry is pushing for these days. So when it comes to regulating height, what can you do as a community? Well, in general, communities are free to regulate the height of structures just on the basis of appearance. For instance, I'm a home builder and a remodeler. Most zoning ordinances prohibit you from building houses taller than 2 or 3 stories, even though 4 or 5 story homes can be built safely. Wind turbines are no different than homes. You can restrict their size for the sake of appearance. Because there's a trap here. Too often I see township or county officials fall into a false debate. Namely, unless you can prove turbine noise or flicker harms health, there is no basis for limiting size or increasing setbacks. But there is no such legal requirement. We can regulate height solely on aesthetics, just as we do with maximum home heights and setbacks, maximum sign sizes, buffers, and berms between conflicting uses, etc. I don't have to prove they make me sick to say they're too big, they're too tall. And we used to have to explain to people exactly how tall wind turbines were in 2010 because there weren't many. And I used to have an arrow that point right here to say this is the normal height now, because these are 552 feet. But of course, the new ones here are up here, and the next ones are going to be far higher up yet. This is my friend Kerry Schindeldecker's former home. He was on the Mason County Planning Commission. This V100, I know you've seen the pictures, is 476 feet tall, and it was 1,139 feet to his house. When the turbines went into operation, he and his wife moved into their basement to get away from the noise. Ultimately, they sold the house at a substantial loss, and a number of them and their neighbors there filed suit against consumers' energy. Mason County, in the meantime, has now adopted or adjusted their turbine regulations, made it much more stringent, and people are not now not finding it economical to build wind energy in Mason County anymore. And like I said, we regulate billboards on appearance all the time. We limit their size, their location, their lighting, not because they make you sick, but we just don't like to see them. You can do that with turbines too. Just not wanting to see them is okay. And of course, Steve Rawlings, regional manager from Detroit Edison, said as much. He was from the Leelanau Peninsula, as far as I know, or at least the west side of the state. He said, there are some pristine places in Michigan where you don't want to impact the view shed. You take a situation like Leelanau County or the Old Mission Peninsula. Certainly there are areas where it would make perfect sense and perfect placement for utility turbines. We probably don't want them as a region there. In other words, he thought it was too pristine. But the turbines in Huron County, apparently they didn't find it to be pristine enough, I guess. But yet we all have a different idea about what's pristine and what we'd like to see in our community. The funny thing is, townships in Leelanau and over on the west side of the state are very left-leaning, very environmentally conscious. They love renewable energy. They adopted stringent wind energy regulations a long time ago, 10 years ago and more. And Detroit Edison CEO concedes that, look, Jerry Anderson, who I think is retired now, you get visual impacts in communities where we've had wind activity. Unlike the Great Plains, which have 10,000 acre farms without many vacationers, land use in Michigan is more mixed. Wind is good for the farmers, perhaps, but maybe someone else living nearby says enough. We plan to continue to build over the next 5 years, but it's certainly getting harder, and Michigan is one of the hardest states in the country for building wind. Well, by the way, he's wrong about that. Much harder to build wind in Ohio, just ask Apex, and it's very hard to build wind in Indiana. 35 counties in Indiana have adopted stringent regulations for wind, to the point that the wind lobby is pushing hard to take control of zoning for wind energy away from the counties in Indiana. So back to our fundamental question, how tall is too tall for your community? Well, like any other land use, it's up to you. Pretty simple. By the way, these are 390 footers. They're in Illinois. I took the pictures. Other question is, how short is too short? The shortest height limit for wind turbines that has passed legal challenge in Michigan is 30 feet. I suggest you look up a case called Jonachek versus Bay Township. The developer says we can't build wind turbines at 30 feet. He says you can build all the 30-foot wind turbines you want. It's not exclusionary. Now let's take a look at setbacks. And I'm going to grab a quick drink. We hear a lot of talk about industry standards from various developers, yet when you look at setback distances, you see that, quote unquote, the industry standard varies a lot. We see Michigan at the bottom listed as 1,000 feet. We see France at a mile. So the industry standard obviously varies in the eye of the beholder. And so we look at these safety manuals, and I know Apex is already out priming the pump saying, well, these aren't really setback documents, but nonetheless, I'd like you to take a look at what they have to say and see how you'd interpret them, since they're a health and safety instruction, and we're supposed to protect health and safety. It says, if a runaway operation should occur, the plant must be evacuated immediately by running upwind, and access to the surrounding area in a radius of at least 500 meters must be restricted. That's 1,640 feet. Nordex, in case of a fire in the nacelle or on the rotor, parts may fall off. In case of a fire, nobody's permitted within 1,640 feet. We found another document, a little newer. In the event of a storm event, they should stay 1 kilometer or 3,280 feet from turbines and inside the vehicle, and remain there for 1 hour, even though your home might be at 1,000 feet. Here's a failed rotor in Dekalb, Illinois. My friends measured the debris field at 1,500 feet on a 390 footer. And we see, if you watch the news at all, you see there's a lot of rotor failures across the country and more fires. Here's a failed rotor blade in a sense of what the scale of these devices look like. By the way, the wind developers now, one of the reasons the manuals we have are older is developers claim that a safety manual for their employees is proprietary information and they don't release them. I think a responsible wind ordinance should require that you release those manuals in unredacted form to the public in your application. There's a wind safety manual in Huron County that, in order for the commissioners to see it, they have to sign a non-disclosure agreement. And I FOIA'd it and they won't release it. I don't understand how basic safety information can be a proprietary trade secret that would harm a particular developer when any developer can buy any brand of those turbines and have access to the exact same information, but that's their position. And now we see that, in fact, ice throw is starting to have some real life issues, not just theoretical. In the interest of time, I'm not going to drill down through this. So the criticism is that the safety manuals aren't relevant or aren't on point for setbacks. So I think that's self-evidently silly. But there's a paper out from a journal called Wind Energy called Analysis of Throw Distances of Detached Objects from Horizontal Axis Wind Turbines. And I'm not going to read all this to you. You can look the thing up yourself. But their paper concludes, now mind you, this is a wind energy journal for the industry. It is found that at tip speeds and normal operating conditions, pieces of blade with weights in the range of 7 to 16 tons would be thrown out less than 2,300 feet for the entire range of wind turbines, and turbines operating at the overspeed event conditions could be up to 1.2 miles. For ice throw cases, maximum distances of 328 feet up to 2,000 are obtained for standstill, which I would call ice drop, and normal operating conditions of the wind turbine, with the ice pieces weighing from 0.4 to 6.5 kilograms. Then, to make sure we're not abusing this document, they say the simulations can be useful for revision of wind turbine setback standards, especially when combined with risk assessment studies. Despite all that data, we continue to see developers pushing for 1,000 to 1,400 foot setbacks to neighboring homes, even though turbines have leapt from 390 feet now to 625 or taller. Here's the rub. By demanding that the setback distances for wind turbines be measured from your home on an adjacent property rather than from the property line, which is how we handle essentially all other land use regulations, the wind developer is in essence asking the regulatory body to grant them an easement or trespass privileges on unleased property. I call this trespass zoning. Now, the wind lobby doesn't like the use of the word easement, but if you sign one of their leases, you will see this effects easement, which says the owner of the property gives to the developer a non-exclusive easement for audio, visual, view, light, flicker, noise, shadow, vibration, air turbulence, wake, et cetera, and any other effects attributable to the wind farm or activity located on the owner's property. In other words, they're buying this easement from the leaseholders, but not from the neighbors, even though the leaseholders often don't live on the parcel. And I guess their position is it's only an easement when they purchase the right to do these things to their leaseholder's home. But if they can talk the zoning board into donating the right to do those things to your home, it is not an easement. And that's what their setbacks are asking. Let us have an easement across unleased property by measuring setback distances and noise limits at the neighbor's bedroom window, even though they haven't signed an easement with us. So if we take a quick look at this, we see that developers' recommendations in this case are back down to about 1,000 feet. If you measure that to your home, even though the evacuation zone is 1,640 feet, you'll see a substantial portion of your property is inside this safety zone, this evacuation zone. And I've wondered if there's a fire here and you have to run upwind to get away from it, 300 or 600 feet beyond the house, the neighbor's unleased house, are you at least supposed to knock on the door on your way by and let them know? I mean, just, do they even have a legal right to cross that property? Now, if we move the setback radius, the evacuation zone to the house, that's better. But this entire semicircle here is now encumbered by the neighbor's land use. And this farmer can't build a new house or structure here on his or her ground. The only way to make sure their property is buildable is to make sure the setback distances are at the property line. And it's not theoretical. Here's a map from a project that Exelon proposed in Sanilac County. These gray parcels here are unleased. So like these little house lots don't have leases. This farm here, these farms are not leased. The green ones are, and here's the turbine locations. If you look in, you'll see that these 1,320 foot setback radiuses, particularly for this guy. So this goes across this guy's house halfway through his home or through his yard. You zoom in once more, about half of this guy's farm is rendered undevelopable now. You can't build a new home in there, and you can't build a home there for your daughter who wants to take over the farm, because you would make this turbine non-conforming now to the existing ordinance. Well, what about our property rights? The right to swing my fist ends where the other man's nose begins. That's well established. My freedoms end when they start to impinge on your freedoms. My corollary on this is if my development project requires me to repeatedly punch you in the nose, I should first get your consent, then compensate you for your broken nose. Remember, the express goal of zoning regulations is to separate conflicting uses of land from each other. By establishing setbacks and noise limits from neighboring homes rather than property lines, the conflicting use is actually granted legal access to neighboring property without consent or compensation. I think that's just unjust. And I won't bother to read that. So what is the right setback distance? If you are regulating setbacks to protect families and private property from fire or rotor failure, 1640 or a multiple of turbine height equaling to 1640 as measured to property lines would be a reasonable minimum for 500-foot class turbines. And in view of that ice throw paper and other research we're seeing, bigger setbacks are reasonable as well. And if you want to use distance to protect from noise, you might need much bigger setbacks, like 1.25 miles. What I did in my township, and I encourage you to check this ordinance out, or what we did, I should say, we chose 4 times the height of the turbine to a non-participating property line, but only 1/4 mile to participants' residence. And both those setbacks could be made smaller if the wind company could sign a waiver with the leaseholder to go down to 1,000 feet and the non-participant to go to, I think, 1/4 mile to their home. I'd have to read the ordinance again. So it's a waiver. I think, again, it's important that setback be at the property line, or the ordinance is essentially awarding an uncompensated nuisance and safety easement to the developer at the non-participating landowner's expense. Equitable wind energy zoning should not forcibly donate unleased property to the neighboring landowner's tenant. In my mind, the 2-stage setback with waiver and the 2-stage sound levels with a waiver allows each neighbor then to negotiate with the developer the value they place on their loss of amenity associated with having large turbines and large industrial machines operate on the property next door. The wind company then has to negotiate with everybody who will be affected instead of often absentee landowners and a few planning officials. Let me see. The waiver concept is strong in a legal challenge, and multiple of turbine height setback rather than a fixed distance is much easier to defend in court, because if you have 4 or 5 times the turbine height, they'll say, well, we got 600 footers, we can't build with that. But you don't have a right to build whatever size structure you want, no matter what, just because your economics demands it. And your defense in court is, but look how many 100 or 200 foot tall turbines you can build with that multiple. So it's a very clever way to protect yourself in court with multiple of turbine height setbacks. Here's the other very contentious issue: regulating noise. How loud is too loud, and who do you believe? Well, these are petitions from the Garden Peninsula. 73 people inside the original wind project's 14 turbines all signed petitions asking for relief from the noise. And of course, we see these charts that show that the wind turbine noise is going to be somewhere between a refrigerator and normal speech. But what we maybe don't realize is at night around our homes, we got something more like 20 to 30 decibel noise, not 50. And so it would be a substantial increase in your nighttime noise. So in 2009, the World Health Organization came out with a paper on environmental noise and its impacts on human health. And by the way, I don't spend a lot of time talking about wind turbines make you sick. That's just not my gig. I think the land use, the trespass zoning is by far the biggest grievance that I would have with the way developers insist on developing these projects. But nonetheless, we have to take a look at these noise limits and become somewhat familiar with them. And these are long-term averages. Low noise limits like 30 decibels, no biological effect observed on human beings. This is outside your house. Between 30 and 40 decibels, we start to see some more impacts, mild effects, but the noise might wake you up or disturb your sleep. This is particularly true in quiet rural communities where most of us live. Between 40 and 55 decibels, we see a sharp increase in adverse health effects. Exposed populations have to adapt coping mechanisms like moving to your basement or wearing earplugs or white noise machines. And above 55, adverse health effects occur frequently. And what are these effects? A lot of times it's high blood pressure, it's stress, it's things that you don't observe automatically. Some people report ringing in their ears, some people report vertigo, but some of these things aren't readily apparent until you start to experience them. And people who live next to turbines don't realize they're being affected often until they go on a 2-week vacation somewhere and get away from the noise and realize, oh, wow, that was causing more impact on me than I thought. So here's the problem. In 2009, if you talk about the World Health Organization, the wind industry said, well, they don't mention wind turbine noise in there. Well, why would they? They talked about all kinds of noise. I don't know why they felt it was a special class. So that was their excuse for why they could come in at 55 decibels and ignore what the WHO said. But their new version of this came out in 2018. So 2 points. They say that it wasn't mentioned. Secondly, they say that there's no impact on human health and no study has ever said that. Well, 2018 WHO guidelines address that. They say for average noise exposure, they conditionally recommend reducing noise levels to below 45 dB LDEN, as wind turbine noise above this level is associated with adverse health effects. And of course, the wind guys point out that this is conditionally, but nonetheless, here's the recommendation in black and white. So you understand what this LDEN means, and I know this gets boring. What that means is it's 45 daytime, and then in the evening hours, that's what the E stands for, is evening, you reduce that by 5 decibels, and in nighttime hours at 10 decibels. So in other words, it means 45 day, 40 evening, 35 night. They're all much lower than 55 being adopted in Montcalm County. And if you do some math and convert that LDEN number to a more common in the US LEQ number, it's something just under 40 decibels, which is the noise limit I've been recommending for a long time. And I won't, this talk will be made available, the video will be made available online. And so you can go back and dig through this stuff. But Dave Hessler did a study for the state of Minnesota. He works for the wind industry a lot. He says 40 decibels or less outside of residences is an ideal design goal. Rob Rand, an acoustician, an independent acoustician, and studied a lot of wind turbine issues up and down the East Coast. He says that my township was going to use 45 decibels. Experience in New England has proven that these noise levels are associated with widespread complaints, appeals to stop the noise, and legal action. This one's very interesting. NextEra, who builds, they built more wind turbines in the US than anybody. They had a lot of them in Ontario, and then the tax policy changed, and I think they sold them. Ontario Ministry of Environment has sound guidelines for wind turbines in Ontario that are 40 decibels and 1,800-foot setbacks. So when you go to NextEra Canada's website, they say the Ontario Ministry of Environment sound guidelines for rural areas establish maximum permissible sound levels at residences of 40 decibels. Then they say this, which is consistent with the standards set by the United States Environmental Protection Agency. What's ironic about that is NextEra pushes for 50 and 55 decibels in the United States, but in Ontario, they had conceded that the US EPA would be down around 40. I don't know of any literature that supports a 55 decibel noise limit for wind turbine noise, not correctly understood. So what we did in my townships, we did a 40 decibel nighttime noise limit at non-participating property lines, 45 day. We added some low frequency noise protection. We thought that was a reasonable compromise. We have 163 people on the call now. Just real quick on property values, of course, Apex has probably handed this out to a lot of people. Sarah Mills talks about it because it says that there's no statistically significant evidence of property value harm to neighboring properties from wind turbine proximity. On the other hand, the author of that study gave an interview, and you can listen to it online. He says, I think one of the things that often happens is that wind developers put our report forward and say, look, property values aren't affected, and that's not what we would say specifically. On the other hand, the developers have little ground to stand on if they say we won't guarantee that. If there's no risk to property values, then I would think Apex would quickly offer a property value guarantee to neighbors. And of course, there's several wind industry funded studies that show no loss of property values, but there's a long list of studies that show substantial loss of property values, 14 to 59%. If you want a newer one, you can Google the London School of Economics, and they did a study on UK wind turbines, and you see they show a non-trivial loss of property values of somewhere in the teens, 14 or 17%, with nearby homes to wind turbines. Community acceptance. So once a project's in, what does the community think of this thing? And I'm trying to be conscious of the time. On the other hand, you'll have years dealing with this. So I think a few extra minutes sorting through this is worth our effort. So I just told you that the study by the Lawrence Berkeley National Lab on property values is hailed as the gold standard on property values by the wind industry. So the same lab released this study in January 2018 called National Survey of Attitudes of Wind Power Project Neighbors. And there's a summary of the results. So they did a 4-year study looking at how people living next to wind turbines feel about it. The one thing I would say is the data is polluted or diluted, I should say, by including people up to 5 miles away from wind turbines. That's almost an entire township away. I don't think anybody has much significant impact except from being able to see the flashing lights at 5 miles away. But nonetheless, they broke it down by various distances, which I think restores its utility. So what did they conclude? Wind companies have posted this part a lot, saying that only 8% of the people near wind turbines view them negatively, but that's within 5 miles. I think it misleadingly suggests that most of the people who live near them don't mind them at all. But when you drill down a little bit and you break it down to distances, you see that it goes from 10% to 12%. And when you get within a half mile, 25% of the people start to have a pretty negative reaction to these things. And of course, some of you would be at 1,000 feet or a quarter mile. So 1 in 4 have a negative attitude. Now you say, well, that's not a majority. Yeah, but right now, nobody in your townships is having a negative attitude. I don't think a 25% loss rate for turbine neighbors is acceptable for any land use, let alone one like this. Now we hear a lot of talk, and we hear this and heard it for years, that I went and stood underneath a wind turbine, it didn't make any noise at all. And we hear that all the time. Well, within 5 miles, 16% said they could hear it. Within 1 mile, 56%, 81% within a half mile. So they absolutely make noise. They're certainly not silent. And if you ask the wind developers, are wind turbines silent? They will never say they're silent because they know better. So what else? Those who reported ever hearing the sound, 16% of all respondents, and this is out to 5 miles, were asked if they heard the sound from the turbines inside their home with the windows open or with the windows closed. To the question of whether turbines can be heard with the windows open, 60% said yes. 10% of everybody within 5 miles reported hearing turbines inside their home. To the question of whether turbines can be heard with windows closed, 33% said yes, and 67% said no. Thus, 5% of all respondents within 5 miles reported hearing turbines inside their home with the windows closed. Look, at a half mile, that number is obviously a lot higher. So why can you sometimes stand, or even relatively often stand under a wind turbine and not hear much? They're often not at full power. And if you want to know if they're at full power, the neighbors next to them know. You'll see the rotor blades flex back pretty aggressively towards the tower. You're going to be in like a 25 to 35 mile an hour wind speed range, and you can really hear them. But if you go there in an August day, the odds of them behaving badly is very low. Of the 81% of people living within a half mile who reported being able to hear turbine sounds, 57% reported annoyance and 31% are moderately to very annoyed. I don't think that's an acceptable loss ratio. And right now, nobody in your township that I know of is being annoyed by wind turbine sounds. And change of the landscape, 42% within 1/2 mile of the people near wind turbine projects are annoyed by the change in the landscape. That's not 1 or 2% squeaky wheel, that's a lot. And remember, the people who are not at all annoyed, what percentage of them are collecting wind revenue? And even 3 to 5 miles away, 30% of people are annoyed by the sight of wind turbines. And you know, the funny thing is, leaseholders have told me this even, the things they hate the most are the flashing red lights at night. That bothers them more than anything. And even Sarah Mills concluded very similar things, but in the interest of time, I won't read this out to you. But the main thing is, if residents feel their voices are ignored, the perceptions of wind turbines becomes more negative over time. My point is, these studies have validated what I've been saying for years. One, wind turbine noise is loud enough to be heard in your house. A large percentage of people living within a mile are annoyed by the sight and sound. And even at a great distance, wind turbines are a visual stigma to many turbine neighbors. So if we take a look at the ice throw data and some of these other reports that we see, the wind industry is finally having to look at some data that says wind development adversely affects a large number of people when placed too closely to homes. The question is no longer 1,000 feet or 1320 for setbacks. It's clearly a question of a half mile or a mile and a quarter. Now, briefly, decommissioning and enforcement. I don't get much pushback on these points, even from people who want the wind project to go forward as officials. Decommissioning is a financial guarantee to take care of the removal of inoperable turbines. The debate is on how much should you save and put into escrow. I recommend that your ordinance requires a bond to be posted in an amount equal to the cost of decommissioning, and that amount should be determined by a third-party engineer as selected by the municipality but paid for by the developer. It should include a reassessment every 3 years. Better yet is if you require the developer to post a cash escrow. And now enforcement money. Mason County found this out when they got complaints about the wind turbine noise. They had to take enforcement action, which ultimately put them in court with Consumers Energy. Now, Mason County's reasonably prosperous county, but guess what? Your liability policy doesn't pay for you to take enforcement action. Your liability policy only protects you if you're sued. So what we do and what we did in my township and our solar ordinance direct, for instance, is that you require an enforcement escrow account, so that the applicant has to keep money on hand in your community. In the event that you have to take enforcement action, you have their money available so that you're not using township money. Because frankly, you can't afford $250,000 or $500,000 lawsuit over wind turbine noise complaints. You can't afford to pay for the legal defenses. You will just surrender. Summary. Most land use changes are pretty benign. Minimum lot sizes, for other uses I'm talking about. So if you want to argue about what's the right minimum lot size or how big of a sign in your community, the people will have opinions, but even if you get it wrong, it doesn't cause much harm. Wind turbines are now so big that their impacts are disproportionately large, and they cover entire townships, not one little lot next to a gas station or home. We felt in my township that the change of land use was so massive and the impact so profound that they should not occur without the consent of all impacted parties. The two-stage setbacks with a waiver for both noise and distance require the developer to negotiate with all impacted citizens. It is fair and equitable and reduces community division. Remember, nobody ever came before your planning commission and said, the light coming through my windows is too steady, could you make it flicker? The nighttime noise level is too quiet, could you raise it to 55 from 25? My property values are too stable, could you build some 50-story industrial machines next door to put that value at risk? The old rule with zoning is this: we were here first, we get to decide. Only two types of wind ordinances. The wind company wants you to adopt zoning language that awards them a free safety and nuisance easement across non-participating properties. I think reasonable wind owning demands that those easements be negotiated individually and privately between the developer and the impacted landowners, rather than forced upon them by zoning regulation. And I've repeated this. So that's it for my talk. But what I've done here, in the interest of shortening, hopefully, the question and answer time, is since I've heard so many of these questions for years, I put together a list of frequently asked questions. They're short, hopefully they're right on point. I would say if you're a township official or county official dealing with this stuff, you may want to take some quick notes on this. I hope it's very useful. So first of all, why do you talk so much about the negatives? Well, we talk about the negatives in zoning deliberations because the negative attributes are what need to be regulated. We don't need to regulate the positive attributes of any land use. So of course we focus on the negatives. Another question: are developers a reliable source of information for your zoning regulations? Well, they can be to a degree, but too often I see townships treating developers and their associates as their perhaps only authoritative sources for writing wind turbine regulations. Remember, developers and their experts' primary job is to get their project constructed under favorable regulations that protect their long-term interest, not your residents' interest. This means no matter where the science actually leads, they cannot agree with it if it makes their project economically unviable. Local officials have sworn an oath to protect their citizens' health, safety, and welfare. Developers are under no such oath. Keep that in mind when they are testifying before you. Another question we get a lot: is it too late to change your zoning? The wind companies already signed leases. We can't stop them now, they have a contract. I've heard that a lot of times. Well, when is it too late? Under Michigan case law, developers have no vested rights in your zoning ordinance until two things have occurred. One is they have to have gone through the zoning process and have been approved, and a building permit has to have been issued. And secondly, even if a permit is issued, if they never started any excavation, they still don't have vested rights in your zoning ordinance. Remember, a private contract between landowners or business partners never binds your township or county government to act. Another thing I hear is, what about bias? We often hear officials say, I have to be impartial when it comes to ordinance adoption. There is no such requirement under Michigan law. Every official has biases and preferences for land use. People often campaign for office on land use issues like stop the nuke dump. That is perfectly acceptable. Bias only matters with ordinance enforcement, not ordinance creation. See this case, Pythagorean versus Grand Rapids Township, for more information. Another one I heard this in Cazenovia Township. We will deal with your concerns in the special land use permit process. Sometimes they say we don't need to amend an ordinance since additional burdens can be placed upon a developer at the special land use stage. Technically correct up to a point. In my experience, that's the shortest path to litigation, which is exactly what happened in Cazenovia. If you're uncomfortable with your ordinance and you're not sure it offers the protections you need, issue a moratorium and amend your ordinance. That's the lowest risk method of protecting your community. Conflict of interest. This is always a hot button issue. So far, we have not found a wind project spinning anywhere in the state of Michigan that did not have conflict of interest among their policymakers somewhere in the approval chain. So I know we get conflicting legal advice on this, but I rely upon the legal advice that my township got from Foster Swift in Grand Rapids. If you have a direct financial stake in the matter before you, you must recuse. And this applies to ordinance creation and administration. And why would you not recuse? Clean government matters. By the way, just a quick note, every planning commission by statute must have bylaws in place that regulate conflict of interest. So if you don't have those regulations in place, you need to get with your attorney and take a look at those bylaws. That's a statutory requirement. Often township planning commissions don't have that. Here's another one I mentioned before. Will we get sued for a strict ordinance? People are scared of this all the time. Are you going to be sued by the developer? It's unlikely. First of all, the developer has no standing to sue over your ordinance until they actually apply for permits and then are rejected both by planning commission or board and the zoning board of appeals. That's called exhausting your administrative appeals. Not likely. Heritage sued in Schoolcraft County over the ordinance and it was tossed because they never applied for anything and they didn't have standing. How about the leaseholders? Also unlikely. Leaseholders want to make the argument that, well, you've taken away an economic opportunity through your zoning, but the law says that until you deprive a landowner of all economic value from the property through your zoning, it's not an illegal taking. And how about the residents, the non-leaseholder residents? Can they sue? Well, rarely, but mainly in the case of conflict of interest or some kind of procedural error. So what should you do as a township? I'll get to that in a second. Remember, many townships and counties have adopted regulations that protect their residents from irresponsible wind development. Wind developers often state that they will sue over exclusionary zoning. I first heard this in my own township, and I've already referenced the Schoolcraft County state case. Threats are common, litigation is rare. And the Michigan zoning guidebook says no lawful land use can be excluded when there is a demonstrated need unless there is no appropriate location to provide for the use. I won't dig into this, but there's a 4-part test for exclusionary zoning. And if it was exclusionary, it would be illegal. But the one I want to focus on is there's a demonstrated need right here, because that came up in the lawsuit that NextEra filed against either Ulmer or Ellington Township. And the judge ruled against NextEra and said wind turbines produce energy, which is, of course, needed by the Ulmer Township community. But NextEra's Tuscola wind project cannot reasonably argue that the township will have inadequate access to energy absent the wind energy project. In other words, Apex would struggle to prove, in light of this precedent, that there's a demonstrated need for more electricity generation in your community when you obviously have power now. By the way, this is what I was trying to get to earlier. Litigation is rare, but to be prudent, you should contact your township liability insurer and make sure you have appropriate coverage in an adequate amount. good coverage is generally quite affordable. You hear this one a lot. The state mandated it. We have no choice. First of all, the renewable energy mandate in Michigan is already fulfilled. But secondly, because I heard this so often that the developers are saying you have to let us build under our terms because of the renewable energy mandate. In the 2016 energy bill, I worked with Senator Shirkey, who reached out to Representative Leuthoiser in Hillsdale, and this language was added and is now part of the 2016 energy bill. It says nothing in this energy bill abrogates the powers granted to local units of government under the Michigan Zoning Enabling Act. What's my point? Wind and solar are not a special class of land use. You can regulate them as you see fit. The state will not come in and take control. Another question, how do I know what the people in my community want? Well, sometimes we see a survey. They did that in Ingersoll Township, and they found out that most people were not really interested in a lot of wind turbines there. There's another way that you can find out, and politically, this is pretty good news for township officials. If you want to know what people in your community think about wind, in other words, you want to suit the majority will of your people, which is a right under Michigan law because we have the right of referendum. My advice is to write a strong wind ordinance that keeps your community as it is. If the wind company supporters are large enough in number, they can place that strong ordinance on the ballot. And if they succeed in defeating that ordinance, then you will know most people in your township want wind, and you can quickly adopt the wind developer's preferred ordinance and be done. That's the safest, cleanest, cheapest way to do this. You can write a permissive ordinance and have that placed on the ballot as well, but you will see that experience has shown 24 out of 24 townships have rejected those ordinances. I can assure you that most people in all of your townships are not a fan of these turbines being built under the guidelines being proposed by the developer. We've seen it for a dozen years. So now I'm going to take a quick drink. We're going to go to the open Q&A time. I'm going to answer as many questions as possible. Let me be clear, personal attacks will not be permitted. I don't care to be attacked, even though I'm used to it, but I don't want anybody attacking or taking shots at their township or county officials either. That's not what we're here for. I will just cut you off if we go down that road. Again, I've already answered the who funds you question. Let's not go there. And if there's any state, county, or township officials, I'd like them to raise their hands first, then anyone else. And please state your name at the beginning of your question. So let me stop the screen share. Oh no, I got to go to another slide. So you're all on Zoom and you're wondering, how do I raise my hand in a Zoom video? If you look at the bottom of your screen, you will see this reactions section. And you click on reactions and you'll see an option is to raise your hand. So again, if you're a county or township official and you want to ask a question, you can click that button now, and then let's see if anybody really wants to do that. And if not, then I will open it up to others. Now, if you're on a cell phone, you can press *9 to raise your hand and do it in that fashion. So I will back up again, click reactions, and then raise hand down here if you're on the video. And if you're on a phone, press *9. So now let me see here. Oh, a couple of quick things. RigaTownship.com. By the way, if you're dealing with solar, iiccUSA.org has my solar talk and some resources there, including a draft solar ordinance that is protective of farm ground. And now I'm going to stop the screen sharing. And I see a lot of smiling faces here. And now let me see, how am I going to do this? So I see a Mr. Pat O'Connor here. Let me see if I can ask him to unmute. Can you hear me now, Mr. O'Connor?
Yes, I can.
Okay, go ahead.
Yeah, thanks. I was just wondering if anybody knows if the Apex developers, do they have any building permits yet?
I don't believe they have. They're at the Met Tower stage. They're very early in the development project. So no, I'm 99% certain there's no, I know there's no permits issued yet, no.
Okay, thanks.
Yes, sir. Is there another hand raised? Do I see anybody? Any other officials? Lindsay, do you see anybody else? Okay, I see Cindy Schick. Go ahead and unmute, Cindy.
Hi, Kevin.
Hi, Cindy.
Hey, my question is, if you were to go about a survey process, Is there a best practice for that? Is there a door-to-door? To be sure you're only getting input from your township?
How many people are in your township roughly?
Oh, I'm thinking 2,000 something.
Okay, well, the best way by far, and it's something that I encourage small townships to do, is if you have 5 planning officials and 5 township officials, of course, there'll be overlap of 1. I really recommend that each person, let's say you got 500 houses in your township, assign each official 3 miles of road. And over the next month, just have them go knock on a few doors and ask them their opinion until you've covered the bulk of the township. I think that's the best thing you can do to have good communication, and you'll get the most direct response. People in general are open to having that. They will appreciate the fact that their officials are reaching out to them. And it doesn't take that much time, honestly. If you're uncomfortable with that, then a survey is always good as well. You can mail something out to them, but often people are afraid to spend the money on that. But in my mind, a lot of the Sarah Mills talked about people feeling left out of the process. And I know townships are worried about money, and I get that. I'm a zoning administrator. Money's tight in our half of a township, because we're only half a township. But the best money we ever spent was a letter to everybody talking about the solar project. And it costs about, I don't know, $500. I mean, it might cost you a little more than that, but if everybody feels like they're brought into the process, it certainly can go a long ways to preserving the community and getting their input. So those are my thoughts on that.
And then did you ask them to be mailed back or dropped off? How are they collected?
Yeah, you can mail them back or drop them off. Like we did a survey here on solar last year, and our clerk was real good about it. And she said, just have them put them in the drop box in the door, and I will gather them and make sure everybody in the community sees how those turned out. And in fact, she said, even if they went into the ballot box, she'd be careful to sort them out when you got the exterior ballot box. So
did they indicate who signed them?
Yeah,
we
asked people to sign their name and write that down on there.
Thank you.
Yes, ma'am. Any other officials that want to ask? Okay, at this point, I will open the questioning up to anybody that wants to ask. Just raise your hand. Click the little, okay, we have a Cheryl Hauser there. Let me ask you to unmute. Okay, unmute, Cheryl, and I can hear you.
Hi, Kevin. How are you?
Good.
Good. Has anybody challenged the criminal trespass law regarding them coming on private property regarding non-lease owners?
You mean as far as the noise, what I'm calling the trespass zoning thing?
No, if they want to come across your property for maintenance, say a fire, or posting your land as no trespassing, or telling them they can't trespass on your property, Michigan criminal trespass law.
Well, no, I mean, people cannot enter your property, particularly if it's posted. They have no right to do that. And so that doesn't have anything to do with zoning. That's just a matter of law. So if you post your property, people cannot enter, and officials cannot without a warrant. So I don't know if anybody's ever gone after people for that, but I do occasionally hear of mistakes made by developers where a survey crew went the wrong way or this and that and the other thing. I mean, I would hope in general, I don't think most developers are running around trying to deliberately trespass, but you have the right to restrict and control who enters your property if you have not signed a lease.
Correct. So that would be the way if this goes through for us just to post our property.
Well, that would only stop them from entering your property, but I'm not sure that they're keen on doing that anyways. It would not do anything to protect you from noise or flicker or those kinds of things, but yes, you have that right.
Right. I understand that. So that was my only question.
Okay, thank you. Okay, I see a Judy Graham. I'm going to ask you to unmute now. Can you unmute there, Judy?
There you go. Okay, you can hear me now?
Yes, I can. Go
Okay,
ahead.
I have two questions.
Sure.
First of all, you mentioned that 30-hour shadow flicker.
Yes.
30-hour, do not quite understand that. Is that per week or what?
That's per year. That's the industry standard, and that's how much shadow flicker can cross your property in any given year. I am seeing a lot more ordinances prohibit shadow flicker altogether on any unleased property. Of course, the developers don't find that agreeable, but I'm seeing a lot of people saying, why would I want to have any shadow flicker on my property at all? The other thing that we've learned in Mason County is that they make these shadow flicker maps that project where the flicker is going to fall. I think they call them butterfly maps. And we were always assured like by the engineers at Exelon that they're very, very accurate. Well, it turned out in Consumers Energy, they were documenting shadow flicker at 9,000 feet and more from a turbine when they thought it would only be something like 3,000. So, you know, there's the other thing is they have software packages now that allow them to stop the turbines when they know flicker is hitting somebody's property or their home. And it can simply be programmed in, and it doesn't work. It doesn't stop them when it's overcast, so there's no shadow. But on the sunny days, when their instruments reveal to them that the sun is shining and that the flicker could be problematic, they know through calculations when it's going to cross people's homes. They can simply use that shadow flicker mitigation software and stop that on your home. So I think 30 hours is too much because you'll get it 30, 40 minutes in the morning, 30, 40 minutes in the afternoon. A lot of people find it objectionable. Some people don't care. I mean, but you're not having any shadow flicker now. I don't know why you'd want it a year from now. Does that answer your question?
Yes, it does. My second question is concerning the survey. What is your suggestion for many of the landowners or homeowners in our township that this is not their primary residence? So therefore, they're not considered actually a voting resident of the township. Yet they, of course, pay, you know, their property taxes at a higher rate because it's not their primary residence.
Right.
How do we get them included so that their voices can be heard?
Well, it's interesting since they don't vote here, but they have a financial interest here. They're very much like Apex, aren't they? And yet we're giving a lot of deference to Apex's wishes, even though they don't vote here. So I think those people, of course, do matter. They do count. And if you follow election law, I'm not going to give you advice on how to honor the election law, but if they can make the case that they're transferring the residents here, they could always transfer their voter registration over to your township. So that's another option. But I think all those landowners matter. They all do, whether they vote or not is not really the issue. And I think they should be included in a survey. I mean, their homes would be impacted like everybody else.
Thank you.
You're welcome. Now we see a Jennifer, is it Ely? I will ask you to unmute.
Hi,
Oh,
Kevin. Jennifer Ale here.
Oh, hi,
First
Jen.
of all, thank you for taking the time to present tonight. I've gained a lot of really helpful information. So thank you to you, and thank you to the concerned residents of Pine Township for organizing all of this. One question that I've had along the way is that I'm personally not for wind turbines, but I'm also not one that's going to try to dictate what someone else should or should not do on their property. I feel really strongly, though, that they should also respect my wishes and not trespass or impede on what I want to impact on my property. I found the waivers really interesting that you were talking about earlier, and I was wondering if you could talk a little bit more about those. At one of our past township meetings, I had talked about having the approval of adjoining property owners if in fact someone wanted to have a turbine on their property. And from my understanding, the township lawyer was stating that that's not possible, that then you're then giving each residence almost the ability to dictate that ordinance. And so I'm just interested to find out a little bit more about the waiver system that you've implemented in your area. And if I'm understanding that correctly, if that's in part kind of what I was trying to mention to our township.
Yeah, I think that's it. I mean, a waiver is nothing more than turning a non-participant into a participant, right? And so it doesn't even have to say waiver, but that's usually how we structure it. we asked that question of Mike Homier from Foster Swift in 2010 in my township. He said, there's no problem with waivers. We do them all the time. I know you'll get attorneys with varying opinions, but waivers are commonly used. I've seen them in lots of ordinances, and I've never seen one challenged in court. So, you know, I'm not an attorney, and watching Law and Order does not put me on a par with whatever your township attorney is. And I can understand maybe constructing some objection to it, but we've never seen it legally challenged. And Foster Swift, who in my mind is one of the leading municipal law firms in the state, is very clear they have no objections to the waiver. So, I mean, if an attorney wanted to reach out to Foster Swift and Mike Homier, I'm sure he'd be glad to chat with them about the legality of it. I like it. I like it a great deal because, frankly, I'm more of a free market guy. I don't like big government. And I don't think my government should be in a position of donating my property to the neighboring landowner's tenant to be used as an easement. Well, let's restore those neighbors' ability to negotiate on their own best interest. And then the government's not in that job anymore. So it's a good question and I appreciate it. But did you have anything? Jennifer's hand is still up. Did you have anything more to say, or are you all set?
I didn't, thank you.
Okay, thanks for the question. Okay, I see somebody here says Vicky's Galaxy. I'm going to ask you to unmute. Go ahead.
Hi,
Vicky.
Kevin.
Hello.
Great presentation. Thank you.
Thank
I
you.
have two questions. You had mentioned that, I guess, in the safety manuals or a standard was a setback of 1640 for a 500-foot turbine.
Right.
So my math isn't that good, how that figures out. What would it be at that calculation for a 600-foot turbine?
I don't know because I don't have a safety manual for that. I saw in the news that Apex was asked for the safety manuals for the turbines that they're proposing to use. And I'm sure it's true. They don't know which ones they're going to use yet. But they know which ones they were going to use.
But they know the height.
Well, they do, but they know which turbines they used in Isabella, and they're pretty similar. And I'm sure they have a safety manual for those. For maybe Apex would produce a safety manual for the ones in Isabella, and you could take a look at that. But remember, that wind energy journal showed that setback distances may want to be increased even above that due to blade failure. So yeah.
Right. And then I have another one.
Sure.
If the wind turbines are considered, I've heard, industrial wind turbines,
Sure.
how can they put them on land that is zoned agricultural?
Well, because we have that right to do that under Michigan law. I agree with you. They're an industrial use. And we see that with utility solar, like the township, 2 townships over for me said, we'll take utility solar, but it goes in our industrial district. And we're going to limit you to only 10,000 square feet of solar on your farm for on-site use or any other district. And I have seen Mason County, Kentucky actually limited their wind to only their industrial district. So you can, but in general, the push is for on ag ground.
And my last question is, I watched the Sarah Mills presentation, and she had stated that there is no, what's the word I want to use? No direct link, health issues regarding turbines. But I'm also under the impression that the WHO recognizes it. Are you aware of that or know anything about that?
Well, yeah, and of course I referenced that in my talk, and they wanted, and so what we hear the wind developers say is, well, we know that wind turbine noise causes annoyance, but that's not direct health impact. Well, a clinical definition of noise of annoyance was posed to me by my friend Rob Rand, and he said it was the interference with the ability to accomplish a task. That's what annoyance means. Well, one of those tasks is obviously sleep. So, the argument is low frequency noise that I can't hear and directly impacting my health. Well, I know friends who I trust and respect a great deal who feel very strongly that the low frequency noise was bothering them and keeping them awake. In fact, I know of one fellow in Ubley, Michigan, who actually has a house rented in Ubley. And when the wind blows out of a certain direction, they look at their phone and they go stay in the apartment instead of their home. So I know these things are happening, but can I prove directly here that they're direct health impacts? No, but annoyance, is not happening now to anybody in your community from.
Right.
And
Okay, thank you.
secondly, it's really funny. They will admit that, well, of course, wind turbine noise can be annoying. And so we know it will be pervasive across large tracts of ground. But then their position seems to be that even though they make a lot of annoying noise, that doesn't mean your property values will be harmed. Well,
Yeah, right,
kind of a disconnect there in my mind. So,
right.
all
Thank
right.
you.
Thanks, Vicki. Okay, I see a Joe Spalding here is next. I'm gonna ask you to, oh, go ahead, Joe.
Awesome. Hi. So Joe Spalding, my pronouns are he, him, and his. I'm a Latino housing activist. And I'm actually a friend of Peter St. Clair, just to get everything out on the table, but he did not ask me to be here. I attend planning commission meetings, city council meetings all over the country quite often. And with housing, a lot of people aren't aware that the history of zoning specifically is designed to lock in existing segregation. And one of the reasons why people don't know this is because a lot of the folks that attend the planning commission meetings are predominantly older and mostly retired and mostly white. And there's a lot of reasons for that. My question to you is, I see a lot of that same dynamic reflected in the opposition to wind energy. So I'm wondering which prominent activists, BIPOC activists, people of color, have you consulted with when it comes to making these pushbacks against renewable energy? That I understand you view the infrastructure cost as being too high for what we get in return. But at the end of the day, I'm also young and I'm looking at climate arson coming through my computer tonight. So I would like to know which activists of color that are prominent in Michigan you have consulted with when it comes to the necessity or lack of necessity of new renewable sources of energy. Thank you.
Sure. Okay. Now I'm going to mute you now. Great question. I appreciate that. We work closely with the Keweenaw Indian tribes in Baraga, who were very concerned about the wind development going in their hunting grounds along Keweenaw Bay. So that's the first question. Secondly, you're right. Peter's perspective, and I presume your perspective as well, is that wind energy brings great blessing to communities. And my brother and I were having this discussion today. We think that it's high time that people of color in places like Saginaw, in Detroit, and Flint experience the blessings of renewable energy development on a utility scale in their communities. I think we should very much start building large wind turbines in those cities and in the city of Ann Arbor, so they can experience these things firsthand. Thanks for that important question. I see
that response was so awesome. Thank you so much.
Yeah, thanks. Okay, I see a Mr. Kalsh L, and I'm going to go ahead. I can hear you, sir.
Well, actually, it's a woman.
Oh, forgive me. Forgive me.
It's okay. It's okay. You had kind of mentioned that Michigan has low wind volumes. So
Right.
I want to get your perspective of why these companies are even coming into this area to generate something that's not even going to fuel a high revenue for them. And we don't have the infrastructure from rural townships to get it to communities, you know, or infrastructure to get it to the areas where it will be used and developed. I'd like to get your perspective on that.
Yeah, that's a great question. The reason so much wind and solar has been built in Michigan is because we have a mandate that says all our renewable energy must be generated within the state of Michigan to contribute towards the renewable energy mandate. Unfortunately for the state of Michigan, it's unconstitutional for a state to interfere in interstate commerce and restrict out-of-state wind and solar developers from accessing our markets. But the only people that have standing to challenge that, it would be people from Consumers Energy and Detroit Edison. And they are making very large profits on the renewable energy development that's taking place within the state. It's unconstitutional. I addressed that with the Senate in 2015 and 2016. Senator Knopf and others, their legal counsel told them it was unconstitutional to restrict out-of-state renewable energy from coming into the state. And at the last minute, they put it back into the law. So that's why it's happening. That's what took place. Ratepayers and the climate are paying a price for that. Did you have another question, or was that it?
No, I think that's addresses it, in terms of the cost, we're generating the wind here at a minimal rate, but then the cost isn't generated back to the consumers because it actually costs more. So
That's
there's
right.
benefit.
Yeah, the benefit is primarily consumers' energy and groups like Apex.
Exactly.
Yes, thank you. Okay, I see another person here, and I see a male face and a female name, so I'm not going to take a risk with this. I'm asking you to unmute and go ahead. Unmute. Mr. Reynolds, is that you? Did you unmute? Okay, go ahead.
My name is Ben Reynolds, Douglas Township, Montcalm County. You touched on such a thing that people on the board, if they stand to profit financially off of wind turbines on their property, they should recuse themselves from participating in drawing up a new ordinance.
Right.
We have people on our board and our planning commission that it's fairly apparent that they intend to sign, but they say they haven't signed yet. So are they just using a loophole?
Oops, I lost you. I presume everybody else can hear me. Can you hear me? Okay.
I got you.
All right, good. So I'm not going to take a guess about those particular folks, but I have seen it done before where officials deliberately choose not to sign until after the ordinance is complete. It would be impossible to make a case out of that unless you were party to their private verbal discussions between the developer and the official before the ordinance was made. I think that good, clean government should not do that. I think people should recuse and be honorable. And if you really want the project and the money, you don't have to keep the township job. You could always just resign. I mean, you got a lot of options there, but it doesn't seem to go that way. Particularly troubling to me is, and I haven't read the Apex lease for your county, but the one in Isabella County had a clause in there that said that, as I recall from memory, I could be wrong, and I'm sure Apex will correct me if I'm wrong, but it seems to me the clause that was in there, this is 3 years ago, said that the developer could bring suit against any governmental entity in the name of their leaseholders. So if you think about that, if that leaseholder is a township or county official, they could actually be suing themselves through their lease contract with Apex. That strikes me as very troubling, but I'm not going to cast aspersions on anybody at your community, but I think if you have a signed lease or you intend to lease, the honorable thing is to recuse.
Okay,
all right.
Thank you.
Thanks for your question. And there's some character here named Norm. I smell a rat. I'm asking you to unmute Norm.
I'm unmuted now.
Okay.
Hi, Patty. Anyway, you talked about 40 decibels and 45 decibels and 50 and 55. And I've said more than once that that would be extremely annoying depending on the decibel level. But can you explain to particularly the township officials that 70 and 75 decibels that they allow in their wind ordinances would be a little bit more troubling? Can you explain how it can happen?
Over 2 decades ago, this was a thought.
All right, somebody's unmuted there. So your question is how, despite having an ordinance restriction of 45 or 50 decibels, how we might get noise levels much higher than that?
Absolutely.
Yeah, that's because the LEQ number they use is an hourly average. They average the sound for an hour. So, I mean, I have some fancy charts to talk about it, but my talk's already kind of boring. But if you have, here's how deceptive it is. And I wish I had the chart included. When you have an LEQ number, a 1 hour average, let's say that you're recording nighttime noise in a community, and for 59 out of 60 minutes, it records 25 decibels. And then one car passes your meter for 1 minute at 65 decibels and then leaves. It just raised the hourly average, that LEQ number, up to 45 or more, even though 59 out of 60 minutes, you only heard 25 decibels. So the same thing happens when you're recording the wind turbine noise. You may get 48, 50, 55, 59 minutes of 40 to 47 decibels, but you may get 2, 3, 4 minutes of 65 or 70, but the hourly average would still be in compliance. But guess what? If it's flipping at 70 and it's got ice on the blades or something like that, you're awake, even though for 57 of the minutes it complied. It only takes a minute or two to wake you up. So does that answer it, Norm?
That answers my question pretty well. And I saw on one of your charts that 70 decibels is the sound of a vacuum cleaner. And that vacuum cleaner is not just running outside your bedroom window, maybe at 3 o'clock in the morning, but it might be, it's intermittent. It's like that vacuum cleaner being turned on and off and on and off and on and off for maybe 3, 4, 5, 10, 20 minutes.
Right.
And that's something I think the officials don't understand. So thank you
Right.
very much.
Okay, very good. Thank you. And the way around that is to just adopt an ordinance that says L max instead of LEQ, which then it becomes like a speed limit. The second you go over 55 and a 55 speed limit zone, even if it's 56, the fact that your hourly average was less than 55 doesn't get you off the hook. So something to keep in mind. All right, I see a person named Brandy. I'm going to unmute and go ahead.
Thanks, Kevin. I'm in Cato Township in Montcalm County. And on one of your slides, you talked about when a township is reviewing or there's some questions about their ordinance, that the lowest risk policy would be to adopt a moratorium while that review process is being conducted. Could you
Right.
just explain a little bit more about that without getting too much into the legality, I know,
Sure.
but just where it would originate and how that would work?
Sure. A moratorium is simply a ordinance that you adopt that says we're not going to process, receive, or take action on any wind related permit activity. And that's all it does. Typically we see them for 6 months to a year. The legal authority for them is a case called Sierra versus Tahoe that was litigated up to the Supreme Court. So that's our legal authority for that. And it allows you a pause without the pressure of threat of a quick permit application showing up on your desk. It allows you to go ahead and make whatever amendments you need to your ordinance so that you're properly regulated. And the reason that's important is right now you're dealing with wind energy development, but look, new land uses, novel land uses are only limited by human imagination. We don't know what's coming next. Your ordinance can never anticipate every land use that might come down the pike. I mean, right now, a lot of communities are dealing with marijuana. That was not an issue we dealt with 10 years ago. It wasn't lawful. Well, guess what? Most ordinances didn't have any regulations for marijuana because it was illegal. So now they're dealing with that again. So yeah, a moratorium is a wise move to simply take a time out and stop and adjust your ordinance. I think it's a good move. I think it's wise. And if you do 6 months, you can extend them again. I think up to 3 years they were found lawful in that Sierra versus Tahoe case. So does that answer your question?
Yes, and just one more. You mentioned also that for the most part in planning commission bylaws that conflict of interest is not mentioned, but that there is a law that requires that be in there. Could you talk about that? Is that something that's fairly new or has that been around a while?
I think it's either in the Planning or the Zoning Enabling Act, which were updated in 2006 and 2008, but it's a statutory requirement that planning commissions must have regulations in their bylaws addressing conflict of interest. So yes, if it's not there, that needs to be placed there. There's a lot of ways to do that, but the one thing you cannot do is write conflict bylaws that in fact make conflict legal. That's not one of the options you have. So
yeah, thank you.
All right, thanks. I see a person named Leslie. I'm going to ask you to unmute.
Okay, can you hear me?
I can.
I have two questions, if that's permitted. First of
Sure.
all, thank you for speaking to our group.
You're welcome.
And I'd like to ask if you could speak regarding the tax revenues and is what Big Wind is promising really legitimate, or how does that decrease, or what's the end result?
Sure.
To
Well,
the
a couple
town?
things. First, we hear a lot of talk about schools. Let's be clear. Any increase that you might see to schools will be met with a commensurate reduction in state aid. So that will be a wash. The one benefit would be if you had a sinking fund or debt retirement, but remember, those are millages that don't last forever. Second, and have to be renewed by the people. Secondly, we see a lot of appeals to the tax tribunal on the valuation. And this has been an issue for many, many years, where the developer then appeals the valuation placed, or the assessment placed on each turbine by the local assessor to the state tax tribunal, each turbine individually. And the argument is over which depreciation schedule to use, the one that favors the township or the one that favors the industry. And so, of course, the industry is obligated to fight to pay the least amount of taxes possible, because they have a fiduciary responsibility towards their shareholders. And so we see multiple counties have banded together and invested a lot of money in defending their assessments, and they keep tax money in escrow that they've collected, because in the event they lose, they have to give it back. So you will have to presume that you may very well end up part of an expensive tax tribunal appeals process. But I can't say that there will be no money, but I will say that some townships are finding out it's well under $100,000. It depends on your own tax structure. And I will say that most people have discovered that a $500,000 or $1 million road millage that you pay for yourself will give you more money than just accepting the wind turbines, because the counties get most of the revenue. The townships don't. So that's
Okay.
my experience. I'm not saying I'm a tax expert, but that's what I've gathered after 12 years of this stuff.
Thank you. And if I may, a second question.
Sure.
Can the townships limit the number of turbines? I realize Apex wants 75.
Right. And something weird about that, we see 40, 50, 60 turbines per township historically, and to see 75 being proposed for 10 or 11 townships strikes me as very odd. That's a very low number per township. I don't know if their game is that they think they're not going to get all those townships, so they're trying for a lot, hoping to get 2 or 3. I just don't know. So can you limit them? I would say you'd be better off to apply general regulations rather than writing in your ordinance no more than 3 or no more than 4, because that starts to look pretty arbitrary. See what I'm saying? But you could create a small overlay district and say, well, we would approve them in this 2 sections down here, and we'll create a wind overlay district at that point in time, and then that district would be subject to referendum as well. So there's some ways to do that.
It would not be arbitrary or capricious to limit the height.
Certainly not. You know, we don't even need a very good rationale to limit height. I mean, what was their rationale? What were their findings of fact? What were their health impact studies? If you look at your local zoning ordinance, it almost certainly limits his houses to only 35 feet tall, maybe 40. Did they have a long stack of peer-reviewed data saying 36 footers make people sick and 35s don't? The rationale is we didn't want to see them that tall. That's all the more you need on appearance. Well, you go to Frankenmuth, why do all the buildings downtown Frankenmuth have an alpine theme? Is it because non-alpine themed buildings are unsafe? No, they all agreed that's what they wanted to see. So,
Okay, thank you.
you bet. All right, I see Lori's iPhone. I'm going to ask to unmute.
First of all, I'd like to say thank you for your presentation. And I live in Montcalm County, Pine Township, and many residents has asked our board for a moratorium. And he tells us that that is unlawful. And could you tell me the difference between a pause and a moratorium?
Well, a moratorium is a statute. You adopt an ordinance that says that we're not going to take any for this period of time, any application for this period of time. You can get away, unless your ordinance has language that says you must process an application within 30 or 60 days. You can get away with just saying we're going to wait 6 months or a year because we're updating our ordinance. I wouldn't do it. I think it's stronger to do a moratorium. I don't see any reason to be reluctant with that. It's a piece of paper. You vote on it, you publish in the paper, it's good. So, I mean, that's my thought. But, you know, I tell you this, no matter what Kevon Martis says on this, nothing I say will ever get a township board to disregard the advice of their legal counsel. And I guess it should be that way. But sometimes in these issues, I've just seen a lot more of it than some local attorneys have. But I don't know your township attorney, have no idea who it is, and I'm not disparaging them. But I would not hesitate to do a moratorium. And I know in the counties I've worked with Foster Swift, and I think Fahey Schultz does this as well. They do moratoria, not a big deal.
Okay, thank you very much.
You're welcome. I see Cindy's asking another question. Go ahead, Cindy, unmute.
Kevin, you talked about like the trespass zoning. At what point, if something is in place, does eminent domain come into play in putting power lines through and across people's property? Can that be covered in an ordinance, or is that something that once you've allowed this, then those large scale electrical towers have to come in for the electrical lines?
So let's be clear on that. Eminent domain only applies if you're a public utility. So that would be anything up to the substation. But from the substation to the turbines, the Apex is not a public utility then, because they're not serving a retail customer. And so anything from the substation to the turbines is not subject to eminent domain. Eminent domain does not apply to wind development anywhere, though I have seen some rumblings out west where they're starting to think about making some of these renewable projects subject to eminent domain. One interesting thing about eminent domain, just like with a pipeline, right now, if your township writes an ordinance that let these turbines go in close to your home without your consent or compensation, you have no recourse and you will get nothing. If it was eminent domain, you would at least have standing to challenge their valuation and you'd be paid. So in some ways, eminent domain is more honorable than just having your property donated to the out-of-state fossil fuel funded renewable energy developer by the fiat power of the government as expressed in your zoning ordinance. So that's my experience with that. Eminent domain is nothing to be worried about. On the other hand, in the thumb, it was kind of funny. A number of farmers signed, a lot of farmers signed up for wind development there, but a number of those same farmers were very upset by the thumb transmission loop that came through there, because they don't like farming around transmission lines at all. And so there was legal challenges against the transmission loop, which was necessary to empower their wind leases, but they really don't like transmission lines. So it's kind of a mixed bag on that. So that's what I know on that topic.
So even if, like here in Montcalm County right now, we're talking Apex, later it could be any other company. What happens when it's sold to someone like Consumers or DTE?
Because the power being generated is sold to the wholesale market and not to the retail customer, that part of it is not the utility part. It's not subject to eminent domain. And you can regulate on your township roads, collector lines and, turbine to turbine and turbine to substation lines. That happened in the Garden Peninsula. Garden Township had turbines, didn't want any more. Heritage went to the township to the south, built more turbines and needed access across Garden. They regulated it in the right of way, so the developer just bought private property all the way across to get his transmission lines in. So that's from memory. I mean, don't hold me to every detail of that, but that's the way it was told to me a few years ago.
Thank you.
You're welcome. All right, I see there's a person named Nancy. Go ahead.
Kevin, this is Nancy Spansky. I'm a Pine Township resident, and sorry about the dog barking. Of course,
And a dog.
Yes. Yep. Go on. Can you go on to somebody else? Okay. Okay. Sorry. So Petra. So the question I have is, as much as we are all hoping for a ordinance that eliminates trespass zoning, I know nothing in the real world is ever absolute. So in the case where the developer or the utility is violating any portions of the ordinance, what role does the township play then in resolving that? And I know this could be a very lengthy answer. I guess what would be the 3 key points that would be important for townships to be considering in that role to resolve those conflicts?
So is your presumption that the turbines get built roughly along the lines Apex desires? What do we do about ordinance enforcement after that?
Yes.
Okay. Well, we typically see a push then for some kind of dispute resolution board. We put together some kind of process that deals with those complaints. And then that becomes tricky because typically the way the developers push for it is they want a couple of their folks on the dispute resolution board, a couple of the township officials, and maybe one member of the public. And I've seen that proposed a lot of times. I think the entire thing should be managed by township officials and residents only. The applicant would be that'd be like asking to be on your own jury, right? If you're charged with a crime. But honestly, once the turbines are up, your complaints about noise and shadow flicker are never going to be mitigated very much unless you have a lot of money and can fight it. That's the bottom line. Once they're in, you're going to live with what's there. My advice is to make sure you're protected now with your ordinance. That's the best I can say.
Thank you.
You're welcome. I see Vicky's got her hand up. Looks like we're running out of questions. Go ahead, Vicky.
In your ordinance that you did you have any wording in there on setbacks from lakes or body of water?
Well, that's a good question. Huron County in their ordinance did adopt a 3-mile Great Lakes shoreline setback. I've also seen other communities do large setbacks from natural features like lakes. I've seen discussion in Illinois of trying to keep setbacks away from natural features like the Sauk Indian Trail, things like that. So the bottom line is you have the right to protect natural resources in your township, including wildlife. And I recommend you do that. One of the things you can do to protect bats is to adopt the practice of raising the cut-in speed for wind turbines to a point above the speed at which bats no longer take flight. Some developers are starting to suggest they will do that. Most resist it, but you absolutely have the authority to do that. You have the right to protect the resource in your community. And I'll tell you a really funny one. I was in St. Clair County giving a talk. I think it was St. Clair County. It's wherever DTE has a big gas-fired power plant over there, and it has a lot of cooling ponds. And the gentleman at the end of the talk said, well, you know, we have a lot of waterfowl and wildlife that settle in those cooling ponds all through the winter. And I'm really worried that if we build a lot of wind turbines around that power plant, they're going to put the wildlife at risk that live in those cooling ponds. So they were actually talking about doing a setback from the power plant for wind turbines in order to protect the wildlife that's sheltered in the warmer cooling water all winter long. I don't know if they did or not, but
And then one last one.
sure.
So this is regarding leaseholders. When the project is sold, which there's a history of them doing that. One, I don't know how many times they are sold. How long does that tie up a person's land that has the turbine on it? And if the leaseholder wants to sell their property, how does that work with a turbine on it?
Well, you could sell the property either with the lease as part of the sale, or you could keep the lease, and of course you get less money for the ground in that case. The lease terms vary. I've seen 30 extendable to 60. I heard from Roger McEwen, who was at Iowa State. He once said that he had seen an Iberdrola lease that extended out to 180 years.
That's what I've heard.
Never seen that in person. I will say there's a limit to how long you lease in Michigan for certain uses, because what happens is it triggers a section of the tax code where it's treated as a sale, even though it's leased. That doesn't mean they take ownership, but for tax purposes, it uncaps the lower tax evaluation that we have as homeowners. So I will also tell you that the perception is that everybody that leased turbines in the beginning thinks it's a wonderful idea and they fight tooth and nail for it to the end. What usually happens is there's actually a lot of buyer's remorse for many farmers who sign their leases, particularly when they see the opposition from the community, because I live in a farm community. I've farmed with guys, driven a lot of tractor, went to the elevator, all that kind of stuff. I'm not a farmer, but I understand their mindset. Farmers are neighbors. Their neighborhood is a hugely important value for our rural farmers. And I serve on a planning commission with several farmers. One of them actually had a wind lease in my township, only to discover he was going to be surrounded by solar panels in the neighboring township. And he came and talked to me, which was hard because he knew where I stood locally on the wind issue in my township. He says, Kevin, when we went to the meetings, the company told us that we were basically going to be heroes for our community, that we were going to bring money into the schools, money for the roads, and everything we're doing is going to be a huge benefit. And we didn't want to miss out on benefiting our community. He says, then I went to the first township meeting and there was 100 angry people there. And I told the guy, I am never coming back. Those people hate me now. And this isn't what you told me was going to happen. I've had leaseholders call me who signed, thought they were safe because the company that they signed with had gone belly up. Next era bought their leases. The guy's in tears saying, I'm taking anti-anxiety medication. I want out of this lease. Can you get me out of the lease? I don't have any power to get anybody out of their lease. So I know there's a lot of leaseholders that have regrets after the fact. You know, so for what it's worth.
Thanks.
Yep, you're welcome. Sure. I see Linda, I think. Go ahead and unmute.
Yes, it's Linda this time.
Okay, very good.
I'm following up on Vicky's comment there with the lakes and what have you. Montcalm County has a very high water table here and 122 lakes, I think I've heard. I'm in Douglas and we have probably half a dozen here. We also have the Flat River that cuts through Montcalm County, or a big part of it. The DEQ, we've had a little bit of conversations with them years ago. They're quite particular what they will allow near the water or wetlands, that type of thing. Is that something that could deter Apex from constructing their industrial turbines here?
Well, I missed part of your question, but look, Fish and Wildlife has some regulatory authority, but they don't enforce it. So for instance, they told the Garden Peninsula wind project up there twice, don't build here. There's migratory waterfowl here. We don't recommend any turbines within 3 miles of Great Lakes shoreline. Well, you go there, there's turbines up and down the peninsula. They ignored it. They have no regulatory authority. So my point is, you can protect your rivers and you can protect your rivers and lakes by applying reasonable regulations that set appropriate setback distances. You know, and all you need is a finding of fact to justify why you did that. What was your rationale for that? And well, Fish and Wildlife has these recommendations. We had concerns. We took testimony from a biologist, et cetera. And that's all the more you need. You just need a rational basis for the regulation. Curiously, environmentalists who fought to protect these species now show up on the behalf of massive fossil fuel corporations like Detroit Edison and want to give them a pass on any impacts they might have on birds or bats. I find that a little ironic. So
yeah, thank you.
You're welcome. Okay, I see Amanda. Go ahead and unmute.
Hi, I have a question. Can our township just say no? Like if we did some kind of a vote, can our township just say no to wind turbines?
No, I wouldn't do that. Now in Indiana, I think one county did a ban and I think it survived a legal challenge. But I don't recommend that because we want to avoid exclusionary zoning. But you can apply reasonable regulations. You say, well, 100 feet is tall enough. A mile setback from natural features is what we want, et cetera, et cetera. It's just, there's a reason we do it that way. And that's because it's the strongest defensible approach to these things in court. So an outright ban, I would not recommend, no.
Okay, and then I have one more question. Can the wind turbines, when they're put in and they can affect our water table, like our well water, is what I've heard. Is that true? And if so, how far would that affect or could that affect, if you know?
Well, Apex is going to agree with me on this one. I know personally the folks who were dealing with the water issues over in Canada. I met them in Indiana, saw a bottle of the water they dealt with. We don't have those issues here over in, it's still in dispute. I think my friends that I met there are being totally truthful, but they did a lot of pile driving over there into shale soils, which appears to be what caused some of the well issues. They don't do that here. And I don't think that's going to be a problem. The high groundwater could be an issue for their construction purposes. But, you know, I'm a builder. We dig basements into wet soils and then we have to deal with the water. But me building a basement next to your property doesn't take your drilled well away. If you have a surface or dug well, it could. But guess what? That dug well is already illegal. So no, I think in our area, the groundwater concern is not a very substantial issue. I mean, it's always good to be wise and prudent about it, but you know, I just haven't seen it here. So there, I'm not just negative.
All right, thank you.
All right, thank you. Okay, I see David Bean here. Go ahead, unmute. Oh, Unmute, David. I can't hear you. Oh, go ahead.
Is that on there now?
Yes, sir.
Well, I don't have any questions, but I just had a statement that Mr. Martis, I surely appreciate, I'm a resident of Montcalm County, Pine Township. And one way or the other, I definitely believe in direct science and everybody doing their due diligence on research. And sir, I commend you on what you have been able to do for us tonight. And I just want to extend my gratitude and thank you. Thank you.
Thank you. Bless you, sir. I appreciate that. I see a 616 phone number here. I'm going to ask them to unmute. 616, last three numbers 064. You want to unmute? I think you have to press *6. Is that correct? Telephone number 6. Yeah, okay, go ahead.
Okay, I'm good now.
Okay.
Hi, Kevin. This is Pam Hemis. I'm in Montcalm Township.
Okay.
And I just had a couple of things. It was pointed out to me, and I don't know if we have any leases on our, or leasers. No, yeah, well, anyway, the people that have leased the land,
Sure.
whether we have any on our call tonight or not, but it was pointed out to me that if your property that you've leased is not yet registered, you can still get out of it. And I have also just heard by the grapevine that there are some people that are concerned that they've signed the lease. And just to make sure everybody knows that they can still get out of the lease if their property is not yet registered. And that's true, correct?
Not completely. I'm sorry.
Okay. Okay, good. Tell us.
The lease is binding whether you recorded it or not.
Okay.
So I'm not saying you can't ever get out of a contract. I can say it's hard. I can say the people I've seen that have been successful never cash the checks, because usually
Okay.
a contract will have a phrase in there to say, well, in consideration of X amount of dollars, we sign this contract. And if you haven't deposited the money, then the contract has gone into effect. I'm willing to bet that most people that signed the lease were more than happy to deposit the money. But I'm not a contract lawyer. I'm a general contractor. And if people are concerned, then they should go see a competent attorney in these matters. But I will tell you, I have seen when a permissive wind ordinance goes to the ballot box, I have seen that leaseholders who wished they had not signed then actually swing the other way. They stay quiet about it because of their participation clause, but they often go into the ballot box and vote against the project as a way to get out of their lease.
Okay, great. That's good information. I also wanted to ask, I've seen that there is a lot of misconception that the electric that is produced in the county doesn't stay in, people think it stays in the county. And that's largely not true, isn't it? You mentioned the thumb area going to Detroit, I believe.
Well, that's right. I mean, electricity follows the laws of physics. And so, it doesn't, some people think you get a turbine in your backyard, you get free electricity. Well, it doesn't work that way, not even for the leaseholders. But no, electricity flows through various mechanisms that are too deep to go into here, but there's no reason to believe that your community is going to be the primary beneficiary of it. And we hear people that come out of time with wind turbines spinning, but their lights are still out due to a storm. So it's not going to make your local system more reliable necessarily either.
Okay, and we do have a lot of high voltage transmission lines, or the high voltage lines in our township, in Montcalm Township, and I know there, I think quite a few up in the northern part of the county too. So.
And that's why they're here. That's why they're here. The transmission lines are a much bigger attractant to wind and solar developers than wind and solar resources. Those transmission lines are the thing that draws them. So.
Okay, and I also wanted to say thank you so much for taking the time to do this, and also thank you to Pine Township for getting it going.
Yeah, you bet. And thanks to Lindsay and her team. They've done a fantastic job. Okay, thanks. I'm going to go to the Gorbys here. Go ahead.
Hi, Kevin. I appreciate everything you've said tonight. I've learned a lot. I have a couple things. I just want you to reassure that I'm correct on this, but from what I'm hearing, it's over like 1,000 yards of concrete at the base of one of these, along with a whole bunch of rebar. And is it true with decommissioning that none of that is leaving? It's only like maybe 4 to 6 to 10 feet above that, and then what's above ground gets decommissioned?
Well, they're shaped with a wide base and then a pedestal that comes up in the middle. And the 1,000 yards is too high of a number, by the way. I mean, I've
Okay.
heard somewhere along 300 to 400 yards. I'm sure the bigger ones require more. I know we often hear that it takes 30 10-yard trucks to complete a foundation, but that's a couple-year-old news now. In general, the pedestal part is small, and they would like to have decommissioning usually only go down 4 or 5 feet. Just to remove that pedestal, the rest of the concrete will remain in the ground in perpetuity. But I have seen ordinances that require them to completely remove the entire foundation. Often that is a deal breaker for the developer. They say, well, under those terms, we're not going to move forward. But I have to ask the question, do you want, I mean, Gratiot County now is going to have 400 or 500 concrete pedestals buried all across the place. I mean, I don't know, is that, that's your decision. I don't live there, but I think they should go away. We tear down a coal plant, we take the whole thing. Right.
Okay. Thank you.
Yep, you bet. And by the way, and one other question, I'm going to mute you, but we often hear that wind turbines never pay off their CO2 debt. And again, I'm going to side with Apex on this one. They do, usually in about 18 months, and they actually are carbon negative, but at a very high price per ton avoided. So now I'm going to go to Cheryl Hauser again and ask to unmute. And then I think that may be our last one. Go ahead.
Hi again, Kevin. How much success have you seen other ordinances regarding, like the Flat River is a designated scenic river? Pine Township especially has a huge state game area, and Reynolds Township has Manistee National Forest.
Right.
Has anybody considered adding those as scenic?
Well,
or to their ordinances to be a certain distance away from those areas?
Well, I don't know. I haven't looked at details in many ordinances up there, but I can tell you it's reasonable to take those efforts. I know American Bird Conservancy works with communities to help protect natural resources. Black Swamp Bird Observatory, they work very hard. They're very concerned about offshore wind in Lake Erie because it's a area of national or world importance for birds. It's reasonable and prudent to take steps to protect wildlife from risks of harm. Now, people say, well, house cats kill more birds than wind turbines. Well, house cats also kill more birds than the Gulf oil spill, but I didn't hear the environmentalists give a pass to the Gulf oil spill birds because cats kill more. Secondly, since wind turbines don't replace cats, the wind turbine bird deaths are added to the cat deaths. They're not in replacement of them, they're added to them. And finally, to use a general statistic like all birds across the country ignores what wildlife biologists know. Species impacts are species specific and location specific. And so killing a bunch of condors in California is a much different environmental impact than killing sparrows or robins in the state of Michigan. So that's all I have to say on that. So now I think we're going to go back to Lindsay. I don't see any other questions right now. So
I got a quick question, Kevin.
Okay.
But back touching on that, do you know the size of the footprint of that footing, like say on the Isabella turbines, the 500 footers?
I don't know how big those are. I know earlier ones were roughly 60 feet across, but I don't know
60
about
feet.
Yeah, but I don't know about the big ones now. And it depends on soil conditions, right? I mean, the worse soil conditions, the larger platform you need to hold the device up.
So essentially you're never going to put a building there ever again.
No, probably not. And I tell you, one thing I've observed in Huron County is since their ordinance started at 1,000 feet, then 1,320, then 1,640, when they come to repower those turbines, the ones at 1,000 or 1,320 or replace them, because the ordinance still permits them, they're going to have to move over 320 or 640 feet and build another one. So now your wind lease just put 2 pedestals in the ground where normally there only would have been 1. So you do have a risk of slowly incrementally popping around your property with more and more turbine bases over 50 or 100 years.
Appreciate it. Thank you.
Yep, you bet. Thanks for asking. All right, I don't really see anything else.
Yeah, Kevin?
Oh, yeah, Norm.
Yeah, you've got somebody, it looks like from a phone call that's got their hand up.
Well, I will ask it, but I think that's the lady I just spoke to, but I'll ask one more time.
Oh, okay.
It is. I couldn't figure out how to lower it.
Okay, good, very good. I'm not trying to be not thoughtful, but
No,
okay.
I was trying to lower it, but I couldn't figure out how to do it. My iPad froze, which is why I'm on my phone now.
Oh, okay. Well, go ahead, Lindsay. I think we've wrapped everything up here, and you want to add anything else? I certainly appreciate the time you put into this. Looked like we had as many as 164 people, and even now we still have 117. So your community is interested in paying attention, and that's a good sign. And by the way, I care about our planet. I care about our climate. I care about all these things. I'm not a climate arsonist, and I don't really like being painted that way. I've worked with people of all political persuasions, from the founding member of the Upper Peninsula Environmental Coalition to rabid right-wing conservatives. That's just the way it is. So I'll leave that there. But I do thank you for your time and attention tonight.
Thank you very much.
Okay, and I guess that's it, right?
I do believe so.
Well, I think as my grandfather used to say to my grandmother, let's go to bed, honey, so these nice people can go home.
Agreed.
So I
Thank
wish
you,
all-
everybody, for joining. Thank you, Kevin.
Yep, you bet. Thanks. Bye.
Thank
Bye-bye.
you. God bless y'all.
Thank you. Thank you. Thank you.
Thank you
Thank
so
you.
much.
Thank you.
Thank you.
Thank you.
Thank
Thank
you.
Melissa.
There.
Is there a way we can get the recording? We got on late.